Hi, this is Shawn Miller, an IP research fellow from Stanford Law School, here to talk to you about a neat new tool that we've recently launched at Stanford, and welcome to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 101 of IP Fridays. Today's guest is Shawn Miller of Stanford University, and he created a really cool database for patent litigation cases in the US with the topic of patent trolls, so non-practicing entities in general. So stay tuned for this very interesting interview. But before we jump into the interview, I have some news for you. For example, Canada joined the Madrid system and the Nice system. So starting from 17th of June 2019, you can designate Canada in international registrations, and you can extend existing international registrations to Canada. Also, now Canada accepts classes, so the classification system. And if you have existing trademarks and want to extend them to Canada, you can now rely on the Nice class system. Also, China has updated the examination guidelines for patents. They clarified the time frame for filing divisional applications in case of non-unity. They have examples for specifying graphic user interface designs in titles of patents and how to submit the drawings for graphical user interfaces. Then they clarified that the examiner will use a problem solution approach to determine inventive step. And there has been a clarification regarding invalidation of patents, where a combination of references is examined in invalidation. So now, without further ado, we jump into the interview with Shawn Miller. Today's guest on our podcast is Shawn Miller. If you don't know who Shawn Miller is, he is now a research fellow with Stanford Law School. He received his JD from Notre Dame Law School in 2004. Then he had a couple of stints with law firms. He received his PhD in economics in 2012 from George Mason University. And he has been teaching with a couple of different university like San Diego, and he joined Stanford in 2013. And while he's on the show, he has created a really cool database. Thank you for being on the show, Shawn.
My pleasure. Thanks for having me, Rolf.
So you have created the Stanford NPE, that is non-practicing entities litigation database. So tell us what this is.
Sure. So this is an effort, basically the first major project that I started working on when I started at Stanford about this time 6 years ago, where Mark Lemley and I were interested in, of course, both interested in empirical research in patent litigation, trying to figure out what was working, what wasn't working in the U.S. Patent space, and seeing that there was no publicly available resource where we could figure out who the owners of patents were that are asserted in these lawsuits. And from kind of early first generation empirical research, saw both while empirical and also theoretical, realized that different types of patent owners would have different motivations for litigating, and then also have different sort of behaviors once they were in a dispute. And that really, if we want to run, sophisticated multivariate analysis of different things, of litigation trends, connecting back with patent data from the patent office, that we need to sort of have some categorization of who the patent owners were. And of course, one of the big motivations, of course, is the so-called patent trolls, who I'll call patent assertion entities, phrase coined by one of my friends and colleagues at Santa Clara, Colleen Chen. And she was also one of the motivations for what I just talked about. She wrote this interesting article, I think back in 2009, called Trolls, Davids, and Goliaths, where she's basically theoretically in a neat, concise way talking about, okay, so if you have two monster companies, Apple versus Samsung, duking it out in court, what are they going to be trying to do to each other? What do they want from that litigation? Versus if you had like a small startup going against, one of those big incumbent companies versus a PAE going after whoever they were going. And the thought was that intuitively, I think it makes sense that, you might expect competitors to be more interested in injunction, for example, versus, a PAE might be more interested in, getting as big of a license as they can to the technology. So that's the motivation, is really, we didn't have a publicly available resource for this type of research. And so we were able to start 6 years ago. And it's been a monster project because our ambitious goal is to basically categorize the patent owners in every lawsuit in the United States going back to 2000 through the present, and then keep adding onto it. And categorize them. We have a pretty complex taxonomy as well, with one category of practicing entities, and then 11 different categories of patents or of non-practicing entities.
Wow. And can you give us an idea, like how many lawsuits you are categorizing, or how many of them did you already categorize, and how many are left, and like what's the status?
Of course. So like I said, plug for the website, it's npe.law.stanford.edu. And if you go there, there's a button at the top, I believe, where you can register for access to the data. So we just completed, I guess, so if we look at patent lawsuits in the United States from 2000, filed from 2000 through the end of 2017, you're looking at around 63,000 cases. And these are, of course, district court, the trial level cases in the United States. So we haven't included any of the appeals court cases out of the federal circuit. But so out of 63,000 cases, call that, for those, 18 years, we've categorized probably about 90% of all of them. But we've recently completed 100% of all the cases filed from 2007 through 2017. So we're kind of working our way back. And then soon we're actually going to start working our way forward to add cases from 2018 and the beginning of 2019 as well.
Wow, that's an enormous amount of data. And so if you have 11 categories of, you say you have 11 categories of patent assertion entities, so PAEs?
NPEs, non-practicing entities.
Okay. So can you tell us, like, what kind of categories do you have? Like, what are these categories?
Sure. So of the 11 categories of NPEs, and of course, apologize for all the acronyms.
No problem.
It seems like we do law, and especially in patent law. But so the distinction between NPE, so an NPE, basically someone who does not sell products or services based on the patented technologies. So it's broader, and then whereas a patent assertion entity we see as one that's really in the business of gaining licenses, license revenue, of monetizing patents, and not necessarily concerned about having anything to do with commercialization or tech transfer.
For example, just to give the listeners an example, for example, most universities probably are not PAEs, but still NPEs, right?
Exactly. Yeah. So universities are one of our categories. We actually have we have two sort of university type categories. One is when the university itself, and we also lump together, we have a few cases where it's a government agency is the patent owner, or a not-for-profit research foundation. A lot of those might be, different hospitals, or it might be a research consortium of several universities that all fit into one of our categories. We assign it category 6, so we have numeric categories for all these. And then, strangely, the other university one is way down in category 2, and that's basically that is, you could think of it as it's an IP subsidiary of a university.
Mm-hmm.
So like the Wisconsin Alumni Research Foundation, which has been pretty active in litigation over the years, where they're sort of separate business entities, but are wholly owned or mostly owned by a university. So that's a separate category. Those are two of our categories. So we also have one of our NPE categories is analogously related to the practicing entities. So we actually keep track where a party is an IP subsidiary of a product company, right? So so that makes up that's 4 of our 12 categories. We have 2 startup categories, which are 2 of the more difficult to sort of define and track. But so we have both failed startups and startups that are suing that are a pre-product. And in both of those, we limit our startup is more narrow. It's more startup in the high tech space. So think of more of Silicon Valley startups. And we have 3 categories that we think of as mostly comprising PAEs, although not entirely. And so we have a category called corporate heritage. So we think of companies like Encyclopedia Britannica or Texas Instruments, maybe for a while, where a long history of production, of practicing, and then sort of switching over to a predominantly IP monetization model for a while. So that's something we consider a PAE when we aggregate a couple of these categories and some research that looks at just practicing entities versus PAEs. And then the other 2 are also pretty close. So basically patent licensing firms. So what we think of is we don't have a separate category for the large patent aggregators like Intellectual Ventures or Acacia. But instead what we do is we have, these are patent licensing firms. Type 1 is where there's the owners of the licensing firm are not the inventors. The owners or founders. There's not a connection with the inventors, versus we assign a category 5 are licensing firms that are founded and or owned by inventors of the patents that are asserted. And those are probably, and then another big category that I missed out on, of course, is we have a category just for human being parties, which usually are the inventors as well. And I'm trying to think.
So what would be like an IBM? IBM is generating a lot of revenue from licensing the patents, but they still also have their own research and their own products, and yeah.
So it depends, and for IBM. So the short answer, IBM is going to be a practicing entity, and it would not even matter. So R&D, and you see some of these big companies that'll basically you do research in an area in a specific application that then you never actually commercialize that yourself. So you're not actually practicing that particular patent. We don't make that distinction within the database. So if you have products and services other than IP monetization, then the default is you go into the practicing entity bucket.
I understand. For example, my understanding is that IBM is generating a lot of revenue from licensing out their R&D activities, like researching computer chips and semiconductor manufacturing, although they don't have any own fab anymore, like producing semiconductors on a larger scale, right? Okay.
Well, and that's interesting because then there are so there's similar companies, I think, is it Tessera,
right?
And then, of course, in the semiconductor space, there's quite a few of these where it's where the company does the R&D and designs the chips and whatnot, and then they license out the actual manufacturing. And we actually do have a separate category for that as well. So we call it it's basically technology development companies that are. And we try to distinguish between those and patent assertion entities by evidence that you're sort of having regular relationships with manufacturers who are implementing the technology. It's kind of the one big marker that this is someone that's sort of, it's certainly somewhat subjective, but it's kind of there's an intent, and we look for evidence that this is someone that cares about commercialization versus someone that cares more about monetization.
I have a question about the database, like what kind of information you are gathering and collecting. So, of course, you would have the parties in the database. You would have the outcome of the case, the decision. Do you also collect data about like the damages that were awarded or something like this?
Great question. And so we don't have anything on damages. The big thing is, so we've had considerable help from other scholars and other companies that have litigation data, where a lot of that type of data is accessible.
Mm-hmm.
So I mean, Lex Machina for one, right, has all this wonderful information on outcomes and has their full dockets available for each case. And our idea is to basically have a resource where you can easily identify the lawsuits, the parties, and also, of course, the other big thing we include is the patents.
Ah, yes,
it's kind of going to be much less valuable if we don't have the patent numbers. But so having those three things, we're identifying the case, the parties, and the patents, and when you do that, then you can with the patent numbers, you can sync up with all the various other patent data resources that are out there, looking at how many claims does a patent have, and who was the initial owner of the patents versus the owner at the time of lawsuit. These
has it been challenged or something, the patent, or right?
Well, then the separate one, yeah. So then you also have these litigation resources that have much more detail on what happened to the patent. And our idea is to have a niche space where we're focused on what are the characteristics of the parties. So one thing, so a couple things long term I would like to add to this, and so that people that I think would be useful for research, and also for practitioners in different industries, particular industries, is first, so I would like to identify, have a separate sort of tag for the PAE lawsuits where it's a IP aggregator, right? So if it's Intellectual Ventures or Acacia or one of a handful of others, and then related to that, and then besides that tag, also have for aggregators, but for everyone else, have group plaintiffs, right? So be able to group. First of all, one thing that we do with our parties that's a little tough is right now. So if you have a parent and subsidiaries, they're considered separate entities, but it would be nice to be able to. I mean, you can think of big companies like Samsung, where you have lots of different subsidiaries, and it would be great to sort of have a meta tag that was like, okay, this is like Samsung. So on the plaintiff side, do that. Actually, ideally do that on the plaintiff and the defendant side, so people can start to see, okay, then you would be interested in, if you had this meta tag, you could say, okay, what are all the lawsuits, against all the Samsung companies? What are all the lawsuits brought by the Samsung companies? And then also one of the other things that I think would be useful would be potentially have this linkable with financial data for public companies, right? So there you would want to identify all the public companies and have that are defendants or plaintiffs, actually both, either or. So bring in some of this, but really keep the focus on. So despite the name NPE database, is because our motivation for starting this project was NPEs, patent trolls, and these type of things. But really what we're interested in are characteristics of the parties.
Right. And the meta tag would be probably also very helpful, because a typical strategy of the larger patent aggregators is still to have very small little companies for each lawsuit, right? Right.
Absolutely. Which is difficult in some instances to track down, or perhaps impossible. I think there's a couple of my colleagues out there that have done some great work on this. I'm trying to maybe get a hold of their their list of who they think different subsidiaries are for.
So let's talk about the benefit for the users of the database. What would be a typical use case that you see?
So I'm less certain, because I'm sort of I've had my head in the academy for so long, so I'm less certain about the uses for practitioners, other than to say, having the ability to this is still a resource because basically the database contains every patent infringement lawsuit going back to 2012, and with the party names and the patents, so that if you're someone that's basically, we have this demand letter, you could very easily go on and see, okay, how many times has it been inserted in other cases against other parties. It'd be an easy resource to do something like that. The other thing is, if you're representing clients that are, in certain industries or even particular larger companies, you have an opportunity that you can track down all the lawsuits very trivially that were against and also brought by these parties. And then again, so it's saying, who's suing particular defendants, or what particular plaintiffs who are they suing, and when were they doing that. And then, so I think it's an initial stop to sort of see, okay, these are the lawsuits involving these parties that you care about, or these types of parties.
I would also think that you could, so for example, if you want to protect yourself or like prevent an attack from a non-practicing entity, or be very well prepared, you could maybe do some research, like what kind of NPEs are filing lawsuits in your particular niche of the industry, of the market, and which of these lawsuits have been unsuccessful because the NPE has been basically the defendant has won, basically. The NPE was not successful, and then you could contact these defendants, what their strategy was or something. You would have a really easy way to find out like who was sued in your field of business by these NPEs, and find out about their strategy, like how they defended successfully against the NPE or something.
Yeah, no, I think that's right. And of course, you might need to sort of use our data with another resource as well, sort of, especially with like the outcome data. You might have to go somewhere else for that. But this is something that's going to be more and more readily available. So I know there's also efforts, or even the Patent Office right now is working on more comprehensive data sets on litigation outcomes. So this would be an instance where you have an effort like ours, where it's a lot of sweat of the brow to do research on who these parties are, and then to categorize them. So you have your unique categories, and then being able to merge that with stuff that's more easily grabbed from PACER, from the electronic filing system. And I would say, so that's practitioners. As far as researchers, whether you're like in government or in academia, there's a whole lot of uses. And so what I would say is, of course, we're looking at someone that's going to do something. Someone's going to try to figure out something about patent litigation. But to my mind, I can't think of many studies that you would run where you would not be interested in accounting for different ownership type within the lawsuits. And the reason, again, being because I think the evidence is there's already work out there, showing that a lot of these PAEs will tend to settle very quickly. You have other suits between smaller practicing entity competitors. They tend to maybe go longer and be more interested in actually getting a judgment. And so if to give you one example, so I think there's two types of studies. One is there's studies needed to basically, because when you talk about how is patent litigation, is it sort of running optimally from a welfare perspective, which is a very hard question to tackle. And in my own research, I try to kind of take bits and pieces of the problem, right? And usually it ends up being, okay, well, focusing you more on the cost side versus the benefit side of different disputes and dispute resolution, and saying, well, it looks like, these type entities are, much more frequently losing, coming out on the losing side of these disputes, or these type of disputes seem to take more of the court's resources, given what we think the value of the patents are. But that so you have that sort of study, but then you have another study that's basically we're interested in something else, right? And so I'm thinking of one that I finished recently with on using, looking at data on our new inter parties review with the Patent Trial and Appeal Board, and using the Patent Trial and Appeal Board, their judgment on whether or not someone challenging the validity of a patent, whether or not they have a good chance of winning, using that determination as a proxy for high and low patent quality. So when the PTAB says, yeah, we're going to institute this petition because we think there's a reasonable likelihood of that, some of these claims are invalid, versus saying, no, we're going to deny institution because we think the claims are probably good. So there, it's, of course, that's outside of litigation, had to do some coding outside of this data set. But there it's like, okay, you're using this judicial decision as sort of a screen for, okay, these are the ones that seem to be higher quality versus those patents that seem to be lower quality. But you still want to account for things like, okay, well, are these petitions against practicing entities or are they against PAEs? Because even if PAEs have as high a quality of patents as practicing entities, it could be the case that the judges themselves, maybe they're biased against PAEs, right? So by including that in your analysis, you're able to sort of screen out some of this concern.
Yes,
that
very
looking
interesting.
At two different types
because
of disputes.
that will become more and more important to basically find out about the patent quality by certain markers or something. I think there will be a lot of new products coming to market in the coming years, trying to find out about the patent quality. Yeah, and if patents are enforceable or not, or valid or not. So that's yes.
Trying
Yes.
to predict basically on earlier history of the patent.
Right, and it would be very interesting to see
during its life cycle.
Whether that would be very interesting for NPEs, but also for other companies that want to enforce patents, that information, and your tool would be a perfect connection between, to find out whether certain types of NPEs have enforceable patents or not enforceable patents, or valid patents or invalid patents. And I think that would be very interesting also for practitioners and patent owners. So can we also briefly talk about the general development of non-practicing entities? It started quite early, even before 2010 or so, and then there was the American Invents Act in 2011, and then there were a couple of landmark decisions coming down the Supreme Court or other courts. Can you just talk about what were the important landmark decisions that changed the behavior of NPEs, and in what way did they change? For example, some NPEs were in the press quite hot a couple of years ago, and now the press is silent basically and not talking about it anymore. What happened? What decisions were important, and what happened to NPEs nowadays?
Oh, thank you for that question. So the one thing that I think is still a mystery before getting to what happened to NPEs, let me focus on PAEs as well. So the so-called patent trolls. And my students and I have a paper in this Stanford Technology Law Review called "Who's Suing Us?" that has some of the trends we see in our database going back to 2000 on sort of the share of cases that are attributable to different types of parties. One thing that's tough and it's hard is, of course, because most of the U.S. the trial courts didn't adopt electronic filing consistently until 2001, 2002, 2003. So it's difficult to find litigation data to sort of piece together a complete 100% picture of what lawsuits were out there even before 2000, let alone in 2001 or 2002, also 2 years that we haven't completed. But the reason we're holding them for the end is because they're particularly difficult. Because, for example, you might not have access to a complaint. So you have the parties, and you might have some of these cases, you might be able to get a hold of the patent number that was asserted in the case, but you don't know anything else about it. All this background, I'm really interested in. This is something that I don't think we don't have. Because we do not have good data for patent litigation in the 1990s. I don't think we have good answers on how sort of the rise of PAEs happened. My sense is that combination of loose patentability requirements for functional claims that were tended to be used in software and IT patents, combined the fact that you had a lot of these patents that were issued during the 90s and perhaps more in the second half of the 90s, leading up to the first, the .com boom and bust, that then you had a lot of these patents that then were covering, functionally how to do things using new technology, do things that had been done in the past, right? But using the internet, for example, that then became these sort of amorphous, and there's uncertainty on what they actually covered. What were the scope of these patents? And so I think that uncertainty is actually that's a very useful tool for patent assertion entities. In that you bring a lawsuit against a company that's doing, if you would have done this back 15 years ago, against a company that was doing e-commerce on a patent that its written description talks about, hey, this is like a first generation red box where you can go rent a movie or rent a CD, which is not even around anymore, right? Using your credit card at the mall, put your credit card in there, and then you're going to have this transaction where you'll be able to have the content, the media that you can rent. That those claims, some of the broadest claims, were written in language that was sort of ambiguous enough that it could read on, iTunes or something like that, and may or may not. And you don't know how you wouldn't know how it was going to come out until you were pretty deep in litigation, and that a lot of rational defendants are going to say, well, hey, how about I just give this patent holder a couple $100,000, maybe several $100,000, settle this thing, as opposed to trying to fight it and risk that chance of. So even before eBay, right, there's even an opportunity where you could have an injunction even as a PAE, let alone going to trial and saying, hey, my whole business model infringes this patent. So my sense is that, so you had new technology that the patent law was a little slow in responding to. Okay, these are the types of software patents, e-commerce patents that sort of makes sense to be patentable, and these are sort of the limits on those type of patents that we should have. It took a while for that to work out in the courts, and that combined with, of course, a new technology that was being adopted everywhere, and then you have a recession where you had a lot of companies that sort of failed, and so you had a lot of IP assets with nowhere to go, right, other than to be used a few years later. And I think so. Another thing that I think there's not enough research to know for sure, but I think I mentioned eBay in the mid 2000s, and I think that actually had a pretty big impact on PAE litigation. In my sense, we also see in the data that PAE litigation seemed to kind of take off more in the mid 2000s, around 2007, like a year or two after eBay. And it's possible that a lot of disputes that were before eBay, it would be easier for non-practicing entities to obtain injunctions in court. And so, in a sense, if I'm an NPE and I go to a practicing entity with this patent and say with a demand letter, and say pay me or I'm going to sue, and seek an injunction, an injunction portion might have hung large enough, combined with the fact that maybe these assertions were less frequent in the first half of the 2000s. Perhaps, and this is conjecture a bit, but I think it's a story that sort of makes sense, that more of these disputes in the first half of the 2000s, they settled out of court before a lawsuit was even filed. But so what happened, and I say this, our data is showing 2007, a jump up in PA litigation. That's 4 years before the American Invents Act. And there's been, at the time, I think most researchers and policymakers don't believe this anymore, but around the time of the American Invents Act, there was an argument that the changes it made in our joinder rule were basically post American Invents Act. You had to, this is not exactly right, but close, but you had to file. You could only file a lawsuit against one infringer at a time. So you would have to have, if you thought that there are 20 companies out there suing distinct companies that were infringing your patent before American Invents Act, you could file one lawsuit and lump all those 20 defendants together. Afterwards, you were roughly forced to file 20 different lawsuits. And so we see that in the data where there's a step up in the number of cases that are filed. And some people have said, okay, well, we see this big jump up in PA litigation after American Invents Act, but it's an artifact of that joinder rule. Now, the data shows us that PA litigation really started to take off 4 or 5 years before. And the jump up was pretty impressive to where in our earliest year in the data in 2000, we find there's only about 15% of all the lawsuits in the United States were by PAEs, and that percentage jumps all the way up to 45%.
45%
in 2010,
wow.
A year before the American Invents Act. Yeah, and so that was in that. Then so it hit that in 2010, and then it bounced around a little bit between kind of the low 40s and 50%. For several years until my most recent research that I've done looks at this case. Well, actually, before I get to that, so the most recent thing that happened is 2 years ago. We had this TC Heartland decision restricting where parties can file their lawsuits, which courts, that had a devastating impact on the amount of litigation in the Eastern District of Texas. But stepping back from that, so that was May 2017. One thing the American Invents Act did do is that it authorized inter partes review, where now people had a more streamlined, easier process to challenge the validity of patents outside of court before an administrative agency. And that really came online, and I think end of 2012, beginning of 2013. And I think that had, so a couple years actually before, then the next big change was Alice versus CLS Bank, which sort of restricted what's patentable in the IT and software space. But I think the combination of the availability of IPRs as a cheap way to invalidate patents, plus Alice limiting which software patents are available, and there's evidence that quite a few people have used Alice to knock out patents earlier in litigation than had been possible before. That dampened PA litigation, but my sense is that you might have had about somewhere around a 10% decline from 2012 through TC Heartland, but then TC Heartland really seems like it might have knocked down the amount of PA litigation by another 15 to 25%, possibly even, just by restricting where these plaintiffs can file their lawsuits. And so what we saw was there's actually comparing a project I'm working on, comparing filings in United States a year before to a year after this decision. That said, in brief, basically, that you have to file either where defendants have regular business and where infringement occurred, or where they reside, which the court interpreted as meaning where they're incorporated. And so before that decision, the Federal Circuit had interpreted resides more broadly to basically mean wherever a corporate defendant had where there was permissible jurisdiction, in which for a lot of these American big tech companies that do business everywhere, you can sue in any of the district courts in the United States. And of course, so you look at the year before TC Heartland, and something like 2/3 of all the PAE lawsuits in the country were filed in the Eastern District of Texas, and 90% of all the lawsuits filed in the Eastern District of Texas were PAE cases. And the impact of TC Heartland, basically the year after, saw 70% decline in the number of lawsuits in the Eastern District of Texas compared to the year before. So that it basically equates to so I said 70%. Think about it. This is like 1,100 fewer cases were filed in the Eastern District of Texas the year after compared to the year before. And sort of my rough preliminary estimates are that about half of those cases probably, if we want to be more conservative, we could say, somewhere between maybe 300 and 700 cases were not filed because of the decision, with the remainder of those cases lost in the Eastern District of Texas.
That was a really very good overview of the development of NPEs and PAEs. So we're just very shortly, because we have talked a lot now, but just very shortly, I would be very interested in where do you see this going? Like the NPEs or the PAEs, do they have a future? Will they still make money? Will it be interesting for people, or will it be an interesting business model in the future, or will it go away? Or where do you see this going?
I think it's hard to say now, and that's even for myself, who's been in my own research results and kind of my priors. I've been a bit of a critic of PAEs, and also, at least software patents as they were granted 20 years ago. That I think when you combine all these different recent reforms that we've had, I think that the punchline answer is I don't know. Because even if the estimate here is that even after Alice, we were restricting patentable subject matter, even after creating administrative challenges to validity, even after restricting where cases are filed, you still have about 70 to 80% of the volume of PAE litigation that you had right before the American Invents Act. And I would say it's not dead. It's weakened. I'm not sure what else, if anything, we need to do to try to weaken it more. It could be that that as some of these reforms percolate in these limitations to patentability, that you're going to have fewer granted patents that sort of fit the PAE business model. I mean, this is a possibility. I know one of probably the type of patent reform that's most likely to pass Congress and the current Congress is something that would take back some of the limitations on patentable subject matter from Alice, basically. So it could be that even though the courts might have, if something of creating a subjective and somewhat difficult to implement test in Alice, it could be that the politicians in Washington decide that because we don't like the way that these patentable subject matter cases applied to biotech, we might roll it back in a way that gives PAEs an opening and sort of gives them back some of what they might have lost from Alice and some of these other decisions. And then I think also it's like what's going to be the next wave, the new technology. So if we're looking at what are we going to do with artificial intelligence patents? So, and if there ends up being more of a proliferation of granted artificial intelligence patents, this could be a next wave, new type of asset that could be useful for patent assertion entities. So to me, it's not at all clear that that the PA business model is dead or dying. I think a lot of recent activity is sort of cut back at it.
Yes,
but I think
that's
it's
also
something that's
what I
going
think
to be around for a while.
All right. So we have talked a long time now about NPEs and your very cool Stanford NPE litigation database. Can you just again repeat where people can find this database and where can people contact you if they have any questions about this database?
Thanks, Rolf. I'd love to. So the website is npe.law.stanford.edu. And my email address is smiller@law.stanford.edu.
Perfect. Thank you so much for being on the podcast. I hope your database will be a big success, and I hope you will have a lot of fun with it in the next years.
Thank you so much. Thank you for having me.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.